We are so honored that there are quite a few people who have come from Korea to allow us to have this conversation. And I'd like to recognize them. They have honored us by great sacrifice and travel to be here, time and time zones. And many of us in this room know that that's a commitment. Could I ask those of you who have come from Korea to raise your hands so that we would know that, yes, thank you, good. Okay, keep them up so that be proud that we're, and I know that you've got some modest ones up here on your team.
Well, it's very non-Korean to call attention to themselves in that way.
There you go. Now learning more and more about this. Well, please know that we are very honored and appreciative of the sacrifices that you've made to allow this event to happen. This event is co-sponsored by Pepperdine Law School and the Strauss Institute, which focuses on dispute resolution at the law school, and also the Dispute Resolution Journal. And I've asked some of the editors from the journal to please come up and also send their greetings and a welcome.
Thank you, Professor Robinson. Hi, my name is Amanda Sanchez, and I'm the editor-in-chief of the Pepperdine Dispute Resolution Law Journal. And on behalf of the journal, we just wanted to thank you all for being here. We look forward to just enjoying some great, not only scholarly conversations about the topic at hand today, but also just great conversations while enjoying the day and the beautiful view and the beautiful campus that Professor Robinson already talked about a little. So just to give you a little bit of background on our journal, we're one of Pepperdine's 4 journals, but the distinction between us and the other ones is that we are focused on alternative dispute resolution. And our mission is to build relationships internationally and domestically while solving these disputes, hopefully outside of the courtroom atmosphere through mediation, arbitration, and negotiation, and just getting to talk and have real conversations with people while solving these issues. So we publish 3 issues a year, and one of which is our symposium issue, which is why we also have an annual symposium, which is why you all are here today. So I wanted to take the chance to introduce a couple other editors, including my symposium editor.
Hi everyone. As you all know, this year's symposium is focused on dispute resolution in the Korean community. We chose this topic because of the growth in alternative dispute resolution in Korea. And Pepperdine is enthusiastic to develop stronger ties with the legal community in Korea. Also, on behalf of the journal, we'd like to thank everyone who came here from around the world, and thank you for coming and enjoy your day. And this is our managing editor, Sadie.
Hi, my name is Sadie Park. I just wanted to mention a few administrative things. If you're an attorney in California and are interested in getting CLE credit, we do have a CLE credit sign-up sheet on the front table, so please don't forget to sign up there. We'll also have subscription information regarding our journal if you're interested in finding more about our journal. 마지막으로 그냥 감사의 말씀 한 번 더 드리고 싶습니다. 멀리 와주셨는데 좋은 시간 보내셨으면 좋겠고 혹시 뭐 필요하신 거 있으면 저희한테 꼭 물어봐 주세요. 감사합니다.
I need to extend the apologies of our dean. She had a conflict and was not able to come to be a part of welcoming you. I do want you to know that she is delighted and very encouraging and very much supportive and said, no, we really want you to have this event, and she is very eager for this event to be successful and for you to have a good experience here. I also want to take a moment, though, that if she had come, she would have taken a moment to share with you about the parts of the law school that go beyond dispute resolution. The fact that you're here, I imagine that you are acquainted with our dispute resolution program and the many things that we do in that arena. But I want to make sure that you know that this law school is also very ambitious and very, it's a rising law school in the part of it that's not the dispute resolution part. So there are many things going on in this building. Our academics are increasingly being recognized by other professors at other schools. Our scholarship, the publications. Frankly, Tom Stepanovich is one of our leading publishing scholars. A lot of his work is in dispute resolution, but there are other constitutional law, criminal law. We have an outstanding trial practice team. It's kind of funny for our alternative dispute resolution to be one of our programmatic strengths. Our trial practice team also wins a lot of nationwide competitions against other schools and is well recognized. We also have a Center for Faith, Ethics, and Religion, which includes a global justice program, which every summer we send 20, 30 students around the world to work on global justice issues like human trafficking and those kinds of questions. So you are here as part of the dispute resolution activities at the School of Law. Please know this is a very vibrant community and one that we're very proud to be a part of and to welcome you to as well. So with that, Bob?
Just one, did you mention the program change?
No, I did not. Would you please?
Well, just briefly, we
Go-
hope
go-
today
Okay, go.
to inspire a conversation of the whole. Yesterday we had, I think, a very engaging program in which people were engaged on topics about international arbitration and conflict resolution. And we certainly look forward to the same and maybe even richer conversation with all of you today. We decided to make a change in the last element of the program. And instead of focusing on domestic arbitration in Korea and the United States, while we may touch on that subject, we really want to look at the broader landscape of conflict management. We're going to talk about some of the developments in recent years in the public and private sectors, but in particular what's going on in companies and the kinds of conflict management programs that are beginning to develop. The way clients and lawyers attempt to deal with issues as they bubble up in the system, to manage conflict, to avoid conflict to some extent, or at least minimize troubling conflict, and eventually to resolve it. So we hope that the last program will actually bring a number of our speakers back up together, and we'll have a conversation about what is going on there. We thought that might be a more appropriate way of wrapping up our conversation today. Thanks, Pete.
One other thing that Professor Coe will kind of have to pass me a note about. I want you to know that one of the things we're very proud is that we've just this year instituted a J1 visa program, which means that scholars and academics and judges from other countries can come without being in an academic degree. It's a visiting scholar program, and that we've had a number of, frankly, Korean judges who have contacted us and said, I would like to come, I do not want to be in a degree, I want to be there for maybe one semester, maybe even a little less than one semester, but I would like to have a chance to audit classes, to use the library for research, and those kinds of things. So again, just so that you know, that's something we're very proud of. The other thing that we're also very excited about is that, in fact, we have the Siegmiller Scholarship. And what that does is that allows us to have one student from Korea have a full tuition experience here at Pepperdine to earn the LLM. Is it okay if I recognize our benefactor? Would that be okay? I want you to know Mr. Siegmiller is right here. So. And he and his family have a great love for the Korean people, and that's why he said, yes, we would love to sponsor and host this scholarship. So, and I'll let you know that the time to apply is right now, within the next 2 weeks. So that if you happen to know people that would be interested, it would be wonderful to hear from them. In fact, if we don't hear from them in the next week or two, the opportunity will have passed. So please pass the word on that. Without further ado, let me pass the mic over to my colleague here on the faculty, Professor Jack Koch. He will introduce his panel and get our program underway.
Thank you very much, Peter. In the spirit of ADR, I'm going to take my jacket off, and you are encouraged to do the same if you would like. I know it's not necessarily consistent with the business cultures of some places. You'll note that I'll keep my tie on, though, because the first panel is about international arbitration as opposed to mediation, and we tend to be still a little more formal in that community. I have great honor to introduce a conversation with colleagues that are becoming actually good friends as well over our time together. I've been so well received, such hospitality in Korea when I visit. They were my go-to team when I thought about who we could invite. And the beauty of it is they're actually exceedingly well versed on the topic. So we thought one traditional way to proceed would be to have them prepare remarks and deliver them. But we thought on this and decided the better way to go might be to just have a conversation, and I as moderator would pitch questions to them and have them address those questions in sort of a round robin kind of format. So we're very lucky that first I might just introduce the panel. E.Y. Park is a partner at Kim and Chang. When I was there, I was very well received and surprised, in fact, I should have known this, but was received by people with Pepperdine connections. And so in that wonderfully important law firm, they already had an established Pepperdine connection. He is singular in the practice at Kim and Chang in the area of international arbitration and litigation. He is well known, well respected. Among his many degrees is an SJD degree from NYU, so he's no stranger to American legal education, and that's also the reason I call him Dr. Park. We're delighted to have him. He's a member of not only the Korean bar, of course, but of the New York bar. Kevin Kim is and I elevated him yesterday to say that he was the founding partner of Bay, Kim and Lee, and then I reread the bio, and he was the founder of the Disputes Group. I'm still impressed. I was impressed when I thought he had founded the entire firm because he's much too young perhaps to have done that. Kevin's a good friend. When I'm there in town, he lets me speak to his firm about whatever current issues are going on and always provides a nice lunch. Again, no stranger to the American scene. He has his LLM from Harvard and is a member of the New York bar, and like Dr. Park, is involved in all of the important organizations globally, not just in Korea, but all of those that we in the international arbitration community are involved in. Grant Kim is of counsel to Morrison and Forrester, and don't let his great Korean language abilities fool you. He was born in the United States and educated at a very good law school in Northern California, Hastings College of the Law, if I'm remembering correctly, Grant, and has over 25 years of experience. He has, however, worked, and this is all things sort of lead back to Korea, for a few years at Kim and Chang along the path of his career. And so he knows very well that practice and has been a good student of the developments there, and so we're lucky to have him. So without further ado, let me start with a few questions. Now these are just designed to, as we say, prime the pump. That is, they give us an excuse to talk about anything that comes to mind when I ask the question. But let me start with EY, if I may call him that. One thing that we teach our students is that when you're thinking about the seat of arbitration, that is the place to hold your arbitration from a legal standpoint, you always want to look for a place that's a party to the New York Convention. And these days that includes 150 some odd states. But it's somehow symbolic of involvement and commitment to international arbitration. And I note that Korea became a party to the New York Convention. It's a 1958 New York Convention in 1973. And by then they already had an arbitration statute, which came into place in 1966. And so to that extent, one might say they were ahead of the United States, because we have and still have this rather dated 1925 statute, which is the core of our arbitration law. And only in 1970 did we become a party to the New York Convention. But as a historical matter, EY, is it safe to say that the ratification of the New York Convention in Korea signaled some kind of progressive commitment to international arbitration, or perhaps was it just one of the treaties that Korean diplomats are told, if you want to be taken seriously in the international community, you have to ratify it?
Thank you, Professor Ko. Just first of all, I want to thank you, Professor Ko, Pepperdine, for hosting this event as well as inviting me to speak. I'm very much honored, and I was actually impressed with the Pepperdine as well as Strauss program as to dispute resolution. So I'm very much glad to be here, and I'll cover the questions that you mentioned. Yes, the New York Convention is one of the most important to make Korea to become successful as an international arbitration place as well as arbitration center in Asia Pacific regions. But I would say that it is more of a seed which was sown a long time ago. As you imagine, the seed alone cannot make a fruit. So then international arbitration in Korea has actually flourished back in 15 years. Before that, it's rarely seen, and arbitration, international arbitration, has been a couple of cases in a decade. But these days, actually, the international arbitration is a monthly issue, conferences as well as case filings. Let me talk about briefly as to what has happened back in 15 years. Before the 1973 New York Convention was ratified, Korea was in a very poor state. 1960, the GDP per capita for Korea was $80, which is 1/3 of the Philippines at the time. Now, our GDP per capita is 25,000, and we are the big trading companies, trading nations. Before the 1998, the economy was much more staggered or slow, and arbitration was much less. But after 1998, arbitration has flourished, economy has flourished. What happened in 1998? There was Asian financial crisis. As a part of Asian financial crisis, Korea was bailed out by IMF. Because of the IMF bailout, there are many companies, banks, corporations failed. People were laid off, and then the assets were sold out. A lot of foreign investors, especially Americans and Western investors, came in to buy the assets. A lot of M&As, and those M&A contracts generally has an arbitration clause because they do not want to litigate matters in Korea. So the arbitration has been put in place as a contract. A couple of years later, arbitration has actually led to actual disputes. And starting from 2000, there are growing need of resolving dispute in the international arbitration mechanism. Korean companies did not know how to do the arbitration, and they knocked the door of Korean law firms, and Korean law firms got involved. That's how they learned and involved in the international arbitration scene. So thereafter, during the 2000 to 2010, our economy has grown threefold. The GDP in 1998, it was $400 billion. Now, 2013, it's 1.2 trillion. So it's 3 times more. Likewise, overseas investment has gone up substantially. In the year of 2000, the overseas investment by the Korean companies were $5 billion US. But in the year of 2013, it became 30 billion. So it's 6 times more than before in 13 years. So because Korean companies went all over the places, Middle East, Southeast Asia, Latin America, and even United States and Europe, they actually had the arbitration clauses in the international transaction contracts because they learned that arbitration is better in terms of the efficiencies as well as enforcement. And because of that, arbitration has grown. And also one of the interesting kind of trend is that previously Korean companies did not have much bargaining power. So they had to agree on to arbitration in New York or Switzerland or London because even though they did not know and not familiar with. But these days they are inserting arbitration clauses which is more close to Korea, Singapore, Hong Kong, or sometimes in Seoul. So that's how arbitration has developed. So answering your question, yes, 1973 ratification of New York Convention is one of the most important foundation, but it has met with another nourishing event such as the economies in the context of Asian financial crisis, and that led to the flourishing kind of momentum of Korean arbitration.
Thank you for that. Grant, could I just follow up with you, and maybe you could reflect on the, I will call them the Kim and Chang years. In the book you're writing about your life, there's a chapter called the Kim and Chang years, I think.
Yeah, there's a few other chapters, but I'm not here to talk about that. Anyway, I'd like to start by reiterating EY's thanks to all the good folks at Pepperdine and for organizing this. It's really, to me, pretty amazing. Here we are in this beautiful place, and now all my friends from Korea are here, and some people I don't know. It's like a mini reunion here, and it's wonderful. Any event, following up on what EY said, though, he painted a wonderful kind of macro view of one of the real factors behind international arbitration in Korea. Simply the economy is so international, and there are all these clauses, so you're going to have a lot of arbitration. Sure. But what does that mean about the Korean legal community? It actually doesn't tell you anything at all. I mean, you could imagine a huge growth in international arbitration cases, but they're all being handled by foreign law firms. And what's really unique about Korea is that the Korean law firms just totally jumped on this opportunity and really quickly got involved. In Korea, some people say that Korea has this culture, they call it bali bali. Bali bali is like when you're a little kid and your parents, it's like bali bali, you have to get it, right? Bali bali bali, it's like, yeah. And it's like amazing. It's like, they're there and then zoom. It's like, how'd that happen? I don't know. But really, I went to Korea twice, by the way. The first time was actually between college and law school, and that's when I actually learned Korean because I didn't know any. And I was teaching English, and it was a different experience. But the second time was 2000. And I went to Kim and Chang with the idea that I'd be helping to build their international arbitration practice. And at that time, Korea was really not known at all in the international arbitration community. And I remember in 2002, EY and I went to a conference in Hong Kong, International Arbitration Conference, and people said, where are you from? I said, we're from Korea. And they said, wow. Does Korea have international? I never heard of Korea. You're the first Korean I've ever met at an international arbitration conference. It was like really amazing. Also, when I went to Kim and Chang in 2000, it seemed there was enough work, but it was actually a bit of a gamble. It wasn't like there was just tons of cases. There was a little. I do know, I won't steal Kevin's thunder, but Kevin actually had already founded his group, and I'd always see the same 4 people from Baekhyun and Lee, and but I thought they'd been doing it for 10 years, but I think it was only a few years too, So it was just barely existing. And I was there until 2004. And by the time I left, Kim and Chang had a formal group. There were about 4 or 5 people, who were kind of focused on the area. But then, 5 years later, they have like tripled in size. And BKL now is not the same 4 people. They have, a whole floor of their building. It was amazing. And the one thing, there were a whole lot of other reasons for this, but it was certainly very adventurous Korean lawyers and law firms who saw an opportunity and they just jumped on it. And you have to understand, international arbitration is generally considered to be a very closed club. It's almost impossible for outsiders to break in. The Koreans did it within like 10 years. I mean, they were at high levels in all these organizations. How they did it, they just jumped in, feet first and went for it. And one other thing I'd just like to mention, and I think this is really important too, is that it was a group effort of a bunch of Korean lawyers at the different law firms who are competitors. But, there's a wonderful camaraderie among these people. And it was building a community. And of course, it is to the benefit of all of Korea for Korea to be recognized as a star in this area. And I think that was certainly a very important thing.
Can I just ask Kevin to reflect a little bit, just to give you an insight to Kevin. I think my first recollection, and I know I had met him before that, but I think we were in Hong Kong at a conference. And my job was to defend arbitration in California, which some of you were here yesterday, is easy to do to a point. and I won't digress. But what I remember most about him is I think it was an ICC conference. And at this ICC conference at lunch, he was going around from table to table saying, are you going to the, and I think it was the ICA, either that or the IBA.
Not the ICA, but it's, yeah, sort of IBA.
Yeah, he was already pitching the next conference in which he held an official position, because everywhere you look, he's on the masthead, so to speak. And so to say he's entrepreneurial is to cheapen it. I think he just gravitates towards leadership, and I think it in part explains the Korea dynamism and how quickly they made a name for themselves. But maybe you could just talk a little bit about that.
I kind of start without thanking for Pepperdine for inviting me. But I'm sorry to add another Kim in this panel, and I know this the other panel also have two Kims, and I was already visited. I started my practice in 1988. At that time, the Korean law firms have 20 lawyers, 30 lawyers maximum. We have no idea about arbitration. I have no intention to practice arbitration because I have no idea about arbitration. After 10 years, as EY pointed out, 1998, 1997, end of 1997, we have a so-called financial crisis in Korea. And we have so many transactions within very short period. Maybe Korea is, as Grant pointed out, we have Bali symptom. So we sold so many companies within short period. At hasty contract, like conflict, and they have arbitration. So my first arbitration was 1997, which I personally appeared in front of tribunal. My opposing counsel was from Baker McKenzie. And then I got the idea that maybe we can do this. We should do this because, to effectively assist the Korean client. And nobody believed me. And it took 5 years. I was allowed to establish a separate practice group for international arbitration. And even that time, is when Grant arrived and when he had first arbitration each other, still the people start doubt about the future of arbitration. That was 2002, 2003. But on the other hand, what happened in Korea at that time was 1999, that was 2 years after we had financial crisis, the Korea adopted Unsitran model law, international arbitration law. That is the first Unsitran model law adoption in East Asian countries. Korea is 4 years, 5 years arguably, adopted Unsitran model law before Japan. And that makes huge basis for Korean practice. And another development happens in arbitration in Korea at that time was we had clean record enforcing foreign arbitral words since we joined the New York Convention in a court. So Korean court always enforce foreign arbitral word without any exception. That has good reflection, and everybody believes that we have good system to solve the dispute through international arbitration. And then what happened was 2006, we actually, as also Grant pointed out, we organized a group of lawyers among the competitors. We called the Korean Council for International Arbitration. And we made joint effort to host arbitration conference and arbitration event almost every year. That was started from 2006. And then we start to get positions in international arbitration organizations. They started from LCIA. I became the member of LCIA, Code 2008, 2007, and then 2008 I became a code member of ICC Code, and the UI also take the position of different organizations, and the other colleagues also involved in the International Arbitration Society. That makes the Korea visible in the society. Of course, we have many. We are lucky enough to have many arbitrations arising out of the Korean companies. So nowadays we are very busy. We also busy with even in international investment treaty arbitration nowadays. Now everybody said that Korea became the leader in at least East Asia in international arbitration. So that's a really, I'm really happy and pleased to see what happens so the last 20 years.
I think you were, as we say, vindicated in your judgment about the importance of starting an arbitration group. And I think whoever laughed at you then is not laughing now. Let me just reiterate some things that were said from a technical standpoint. A very big watershed event. I had mentioned that there was a 1966 statute in place, and we know that the ratification of in 1973 of the New York Convention was important, but the adoption of the model law is a singular event in the sense that when an outsider looks at the Korean legal system as affecting arbitration, there is a comfort level that's created immediately when we find out that they're a model law country. That means that they share a statutory structure with dozens of other countries the world over, so that immediately I know that when I'm talking to a Korean lawyer about the grounds upon which an award can be set aside, that they will be based on Article 34 of the model law. And when we talk about the role of courts, the extent to which they intervene, we know that to some extent that will be limited because they're a model law country. Now, each model law country does some slight adjustments when they adopt, but that's a very important event. Could you talk a little bit, just for those of us who are common lawyers and perhaps not involved in the Korean scene, a little bit about the legal structure in Korea? Perhaps at UI you could start and then others could add. Is it safe to say it's a civil law country, and how does that play out in connection with arbitration? Does that affect the approach to it?
Yes, certainly. I should say that Korea is a civil law country, but I would rather say civil law country plus alpha. What does that mean? Well, strict dichotomy between civil law versus common law is that you don't have any stare decisis, you don't have any cross-examination at the court. But our country is different in a strict sense of the civil law countries. When I did arbitration in Switzerland, my Swiss co-counsel suggested that we forego cross-examination because they don't have any tradition of cross-examination. And I told her that I never had an arbitration where I did not cross-examine. And I realized that the Switzerland and Germany do not have a cross-examination in the court. But we have. In the civil procedure, we have a cross-examination. The reason is because we are influenced by the United States. Two ways. After the occupation of Japan ended 1945, United States government, the military government, took a trusteeship under the United Nations for 3 years before Korea started a new republic in 1948. They introduced a number of legislations. One of the introduction was civil procedure and judiciary, and because of that, thereafter we had a cross-examination in the civil procedure, which is a bit different from the substantive law. Procedurally, Korean lawyers are accustomed to do a cross-examination at the court. That's why I think that a number of Korean lawyers feel comfortable in conducting cross-examination during the international arbitration. The second is we have a bunch of Korean lawyers studying in the United States, and then in lawmaking as well as a practice and interpretation, the common law concepts were introduced. So, because of that, the Korea has a civil law tradition, but also it has some common law colors. In terms of the Arbitration Act, as Jack has mentioned, we enacted Arbitration Act in 1999 following 1985 UNCITRAL model law. I mentioned earlier as to the New York Convention. New York Convention was ratified in 73, but New York Convention merely states principles. So if you go to other countries in Southeast Asia, they ratified New York Convention. For example, I had an arbitration in Vietnam, but there was a whole bunch of hindrance and obstacles to get your arbitration through. The reason is because it doesn't provide any specific guidelines. It just merely states principles. But the New York Convention, ratification New York Convention had a much more, I think, effective factors when Arbitration Act was enacted in 1999. The whole concept of the UNCITRAL model law has a threefold. Number one, arbitral the autonomy. The second is a fair dealings of the parties, fair opportunity to present their case. The third one is the limitation of court intervention. So the court is limited in its intervention. So these concepts were introduced by way of Arbitration Act, but at the same time, it lists up the criteria of enforcing arbitral award pursuant to the New York Convention. So then New York Convention became a part of domestic law by way of Arbitration Act. And going further, in the domestic arbitration, the New York Convention only governs the foreign arbitral awards. And then there are many countries where the domestic arbitration is applied, the enforcement or refusal of the enforcement applied in different manner from the New York Convention. But in Korea, actually, Korea adopted the criteria in enforcing the arbitral awards in the domestic arbitration as well, so that the New York Convention become not only a domestic law, but also it governs even domestic arbitration in terms of the criteria and then the principles. So because of that, it became really a part of international arbitration. And in terms of how you conduct the arbitration, even though you have a Korean law, if the governing law is Korean law, civil law, the way arbitration is conducted is very much similar to the way you do arbitration in any of the developed countries, having a number of common law elements such as discovery or document disclosures, or the fair opportunities, and such as cross-examinations and so forth. So those are brought into the picture of international arbitration in Korea.
That's, I'm reminded, bringing this back to the IBA and this sort of, my question, I guess, is the International Bar Association publishes these soft law texts that are guidance in the field of arbitration, and one of them, for example, is now in a second edition. It's the IBA Rules of Evidence for International Arbitration, which covers more than evidence. It's documentary exchanges and so on. Have those documents been influential, or were the Koreans influential in making those documents? Mm-hmm. In other words, had the practice already established, or when those were published, did you see more and more unification around the principles of those soft law principles?
Yeah, that's a very important element. Yeah, you're right. I mentioned about the New York Convention and Arbitration Act. Probably it would constitute a hard law aspect of the arbitration. But then there is a big important area of a soft law, because normally this hard law provides a general guidelines and principles, doesn't talk about the details as to how you do the, investigate the evidences and how you deal with the actual practices and so forth. Those soft laws are covered by a number of institutions such as IBA. IBA issues a guideline on the evidence and party conduct as well as conflict issues. As Kevin mentioned, when we studied arbitration, because there are so few law firms who are familiar with the arbitration, so again and again we see each other in the international arbitration scene. So whenever the issue comes up, as to how you present a document as a discovery or document disclosure. Then I would ask my learned colleague Kevin, shall we do it in a reference schedule, something like that? So he would agree. And what about applying the IBA guideline of evidence? That might be a kind of criteria they would rely upon, and he agreed. So then it's agreed among us, because if you have a domestic arbitration under the Korean Commercial Arbitration Board rules, if the arbitrator or the litigators or arbitration counsel are not familiar with these international practices, and they tend to apply court practice or civil procedures, so then they would limit the document disclosure and so forth. But there are some arbitration lawyers who are familiar with this international practice, generally agree to these practices, and it became kind of somehow a usual practices among the arbitration bar in Korea, and it became more of a accustomed practices and well known, so that anyone who comes into the play do arbitration, they need to know about the reference schedule, the IVA guidelines of taking evidence and conflict rules and so forth. That's how it has been settled into Korean landscape.
Very good. I'm going to switch it up a little bit here, and I'm actually going to quote Grant, but then ask his two colleagues here to comment on what he said, and I'm focusing in particular on the development of practice and young arbitration specialists and the legal training. But he says in one of his many writings, and I forget the date, but it wasn't that long ago, quote, "Korea was barely visible in the international arbitration community just 10 years ago. Yet, Korea is now a major player. Korea not only generates numerous large cases, it hosts frequent arbitration conferences, has created a new international arbitration center, and is even touted as a possible alternative to Hong Kong and Singapore for arbitration in Asia." And here's what I underlined in my quote to continue. "Korean lawyers have quickly acquired arbitration expertise. They are serving as counsel and arbitrators in cases outside of Korea, and have moved into prominent positions in major arbitral organizations." Now, some of that's already been affirmed by what we've discussed, but I'm curious about several things, and I'll just throw in these threads. You said that arbitration bar is relatively small still in Korea, and I just returned from an arbitration-related matter involving a household name based in Korea, and the law firms were English and American. At the same time, we have students from Korea come to, for example, our LLM program, and they're very enthusiastic about arbitration, and they see that as an important part of the future there. So I guess my question is this new generation of lawyers taking to the sort of soft law practices and culture of arbitration, do they, in their legal training, form a sense that this is a viable practice area now? This is something that is no longer a laughing proposition, but something that I would like to do because of all the reasons that we're all involved in international arbitration. Could you just comment on that, and then we'll give Grant a chance to defend himself. Kevin, take a shot at that, maybe.
Yeah. As EY mentioned, Korea is civil law jurisdiction, but it's very common or friendly civil law jurisdiction. Not only the law, actually law itself, actually our constitutional law is quite similar to American U.S. constitutional law, and same applied to civil, particularly criminal procedural law. It's very similar. So we are not surprised to learn the U.S. legal system when you attend the LLM program. But more important thing is, we have about 500 lawyers in our firm. And we have, among 500, we have about 170 American lawyers. That 170 American lawyers include 120 Korean lawyers. So like that, the Korean lawyers are qualified both in Korea and United States, mostly New York, some California. That has huge difference, when you're doing arbitration practice, for example. We are already familiar with American system. We are already familiar with document discovery and the concept. We never resist the adopting such a principle. In 2010, when I was actually the IBA arbitration committee, I was in the drafting committee and the new IBA evidence rules. I was quite surprised to have debate with Swiss lawyers or French lawyers from the civil law countries how much we should adopt the common law concept in international arbitration. So I was surprised by myself that I was defending common law concept in international arbitration because that's so familiar to us. And when you go to international field, our client also never insist on the Korean factors. I just came from Japan doing arbitration, and a Japanese lawyer on the other side argues some Japanese factors in international arbitration. I was not happy with that, and when I actually doing arbitration in Korea, involving Korean matters, we never insist that because this is related to Korea, we have some Korean things. Now the Korean K-pop was quite popular around the world. K-pop is not Korean music. It's nothing to do with Korean traditional music. It's just music. Just we collected ideas from all around the world. You try to make it something, popular in Korea, then the other people around the world like it. So, somebody is talking about Gangnam Style in international arbitration. We are the only law firm in Gangnam. Our competitors are still in the Gangbuk area.
That's true.
Our office is just located 100 meters from the Gangnam station. So when you say Gangnam style arbitration, it's not this Korean practice. It's just something we just insist that whatever is acceptable in the international society should be the Korean thing, and there should be the international arbitration in Korea and other places. And young lawyers are quite ambitious, so we have many young students really eager to participate in arbitration. I think it's a good thing because Korea, in America, we don't have good statistics, but I understand that we have about 10,000 American lawyers, Korean origin. So maybe Korea is the only jurisdiction who can bring more than 5,000 American lawyers outside America, if we want. So that is we have good potential to promote arbitration in Asia and assisting other jurisdictions and working together with particularly the United States when it required to do so. So that is maybe some unique aspect of Korean practice.
Let's give Grant an opportunity to weigh in now. Your reflections not from too far away.
Okay, thank you. I understand Kevin's agreed to give a performance after this panel.
Yeah, well, you don't want to get me started.
I'm a
because
economist, but
I got the thing.
It's something. There's so many things to say. I can't say them all, of course, but certainly Koreans do have a reputation as being fast adapters, and arbitration is obviously definitely in vogue. But picking up on what Kevin is saying, there's been a tremendous globalization of Korea in the last 10, 15 years, not just in arbitration, of course. And that has been a really big help for Korea because international arbitration is inherently international, of course. So there are overseas Korean lawyers such as myself, and not only in the US, actually Europe, South America, New Zealand, I mean all over the world. We actually get together once a year, and it's amazing. We have like 15 different countries there. But there are also, of course, Korean lawyers who go overseas to study and get LLMs, but there are many Koreans now who are going overseas in college or even high school or junior high, and who are not only sometimes trilingual or tricultural. I mean, it's amazing. So that's had a big impact, of course. But I'd like to just pick up on one sort of specific thing on the team. To be effective as International Arbitration Council, it's really helpful to have a diverse team with people with different perspectives. And the one in particular I want to pick up, because it was mentioned earlier, is the common law, civil law issue. You will have some governing law, it might be common law, it might be civil law. You will have arbitrators, maybe some of them are common law or civil law. But having those different perspectives, there are definitely differences. Obviously, I can't go through them. But ultimately, as counsel, you of course want to persuade your arbitrators. And the way that, for example, a lawyer from the US may look at an issue, or a lawyer from England or France or whatever, under the same law can be different based on their own training. So I found that I was at Kim Il-sung many years. I've also worked with Kim Il-sung after that. Most recently, though, I worked with Kevin's firm on a big arbitration involving Korean law. And many of these arbitrations, the law is actually not very important, because it's just a contract dispute, and there really is no dispute about the law. It's what does the contract mean, and what happened, things like that. But sometimes it's really, really important. In the case I worked on with Kevin, it was really important, and I had the privilege of being the American member of our team working on the Korean law issues with the experts. So I got this great education on it. But ultimately, most of our arbitrators were common law. So I was really pushing on the case law. I wanted to argue things based on case law. Korean civil, from my experience, civil law lawyers are much more comfortable with just the abstract principle. Even if they cite the case, they'll just tell you what the abstract principle is. They won't tell you what the facts are. As a common law person, I want to know what the facts are and try to make it, But anyway, by working together, we were able, I think, to make a much better product than if we were just the American side or just the Korean side. And I think that's really helpful to have a diverse team working together.
Iwa, you want to weigh in?
Yes. For the next generation, certainly the arbitration is one of the hot topics among the law students as well as the young lawyers. There are a lot of activities going on. Arbitration or dispute resolution focused programs at the law schools, as well as moot court, and a number of Korean young law students are attending on the Bismuth and similar type of such competitions, and they are known to be more of an arbitration knowledgeable candidate in case they try to seek a job placements. So these are good things, but at the same time, it's also, I think, that we need to broaden the scope. I did actually had an arbitration in Singapore and sitting as an arbitrator. I was a neutral chair between a Chinese company and a Caribbean company, and the governing law was Indonesian law, and I had to render a decision based on the experts. But the problem was the experts was starkly different in Indonesian law. So I suggested that why don't you submit any court precedents. And Mr. Chairman, the council said that, in Indonesia, they do not publicize the court precedents, so we don't have anything to submit. How can I determine that? But then they submitted a number of Dutch laws, because still Dutch law has some element of Indonesian law. So I had to review the experts' opinions and so forth, and I've written a word based on Indonesian law. But I realized that Indonesian law and also Dutch law was very similar to Korean law, because we have a civil law traditions. There's a slight variances and so forth. So I explained this experience at the law school when I taught arbitration, and asked the students put their education in a broader context. So if they are able to connect their knowledges to the outer world rather than only limiting to Korea, I think there are much of opportunities and chances. A small number of the people, of students, try to make an adventure to go outside to become a clerk to the arbitrator, well-known arbitrator, or interns in the international arbitration institutions or the foreign law firms. And then when they came back with the knowledge of these areas, I think they are much more well-suited to do an international arbitration. But I think that it's on the way.
Just to underscore something he said, he made reference to the Viz moot court, and for the uninitiated, it's hard to overstate the impact of what started off 22 years ago, I think, as an idea. Why don't we hold a moot court based around a mock arbitration? And today, I would say dozens, I was going to say dozens, but I think it's hundreds of teams show up to Vienna for what I would call the Vienna version of the moot court. But there's also now one in Hong Kong. And these are teams from all over the world, and even from within many cities within, for example, China and elsewhere. And they meet to moot, to argue a common problem based on international standards, changes every year. And it has grown now in such an educational experience that there are now pre-moots. So in order to practice for the ultimate event, there are regional events where teams gather, say, 10, 15, 20 of them to moot each other on a regional basis. And it really has, over the last 22 years, created sort of a club. So one of the things that now law firms look for on a resume for someone who wants to be involved in international arbitration is to the extent they participated in these moots. And for some of them, this moot exercise is a 6-month-long practicum in arbitration, because they start with the pre-moots, which I gather we now sometimes hold even in Korea, and move forward from that. I wanted to focus, thinking about students and how I tend to talk to my students. We always start with focus on the front end of the transaction. So there's talking about the dispute arises and then how are we going to settle it. But it starts with, before the dispute ever arises in the contract, they're being included an arbitration clause. And so I'm wondering, and this sort of weeds into the question of the role of clients here. How much of your work involves the transactional phase? What is the interaction between the transaction lawyers in your firms and the disputes group? And how do client views, internal policies of clients? Because I know that big Korean companies have internal policies about how they feel about mediation and arbitration, how many arbitrators, what institutions they like, and you help them formulate these policies. So let's start with Kevin, and then I'll pitch to EY.
Yes, I actually, we have many things to say. So, one thing I did not mention is one of the reasons why we have so many arbitrations coming out of Korea. I have statistics in ICC code that say from 2003 to 2013, Korea has 315 cases, while Japan has 221 cases. And China is about 314 cases, one case smaller than Korea. But given the size of economy in China and Japan, the Korea is maybe the quarter or the less of that. So that Korea has a lot of cases. One of the reasons is that we have very good communication with our corporate lawyers. Whenever we have a negotiation, a transaction, our corporate lawyers ask me what will be the dispute resolution clause. Normally, the arbitration clause is known to be like 3 a.m. Clause, which means that at the end of the transaction, you have negotiated an arbitration. all dispute resolution clause, nobody interested in, everybody want go home early. So that's what happens in dispute resolution clause. But a good thing in Korean practice, particularly in a law firm practice in Korea, we normally have good communication with our corporate lawyers. The corporate lawyers, and some of us, arbitration lawyers in Korea, have background, M&A background. So I personally have M&A background. The Bumsu Kim sitting here also have a M&A background. So we have that really help, and then have good understanding. It's absolutely important to have a proper arbitration clause in a contract. Otherwise, we have no chance to have a good dispute resolution. And then we also have many event or conference in Korea. Try to have communication with the in-house lawyers, and in-house lawyers should have the proper idea about arbitration, what would be most proper arbitration clause, and what would be the good arbitration institutions. ICC is always well known. ICC is always very powerful in all jurisdictions. But what happened in Korea was, recently we have many arbitrations in the Singapore Arbitration Center, as maybe Singapore is a really beneficiary of the Korean practice. When I have arbitration when I first involved in arbitration, one of the most frequent questions was, what would be the most recommendable arbitration clause? So I say ICC is good option, and then you can think about maybe Singapore. Then everybody follow that trend, and then we have so many ICC Singapore clause. And we have many arbitration in Hong Kong, and Hong Kong Arbitration Center also have the case. And even nowadays, we have many JCAA arbitration. I was quite surprised. JCAA normally have 12 cases per year, and about 5 cases from Korea. That's quite surprising. So that is just kind of the Korean society really quite interactive. We always exchange ideas and the trend, what's going on in the outside Korea. That is really helpful in developing arbitration practice.
Yes. In addition to what Kevin has mentioned, I have a couple of observations. That is, arbitration is a contract dispute, so it has couple of meanings as to what it means. Number one, the different from the litigation, which will be a default. Arbitration is a product of party autonomy, so you have choices. If you compare with the restaurants, it's not a set menu; it's more of a la carte. So the way you can compose your meal. But many corporate lawyers and clients do not understand that, so that they may just simply think that there will be a set menu. But it's not. There will be a best choice for your arbitration as a client. So our job is to advise a client to get the best choices in resolving the disputes. Especially the seat is one of the most important things. If you chose a seat which has some of the tag-along kind of issues, such as very strict court involvement or any limiting kind of legal mechanisms in terms of the evidences and so forth. But if I had an arbitration in India, and a lot of arbitration counsel in India said that, we need to put particulars for the arbitration, presentation. At the same time, they mentioned about the, admission of the evidences and so forth. So it dragged along the arbitration procedure. So these points had to be discussed with the clients in an early phase in drafting new arbitration clauses. As Kevin mentioned, we had established a program inside our firm to discuss with the corporate lawyers in drafting the arbitration agreement. At the same time, we organized a number of seminars for the in-house counsel so that they are familiar with the arbitration clauses and they have a right and opportunity to choose their the best arbitration agreement for them. At the same time, in our arbitration practice, the members are composed in a manner that the 70% have a litigation background, but 30% has a contract, a corporate background. Especially when arbitration refers to a very specific issues such as M&As and there's a dispute about the tag-along issues, or crown jewel issues, and so forth. We need to have some input from the M&A people. Even we invite corporate people to get involved in conducting and interpreting the contract so that we have a all seamless interpretation and pursuit of the disputes. So those are the aspects I would put.
Good. In the international arbitration community, we have a name for clauses that are not so well conceived or that reflect the 3 a.m. drafting that we're talking about. We call them pathological, because often we've mentioned up here some of the essential elements, the governing law, the seat being very important in the institution, and one is surprised, or shouldn't be surprised even today, knowing the 3M context, to find arbitration clauses that name non-existent institutions, ambiguous choice of law that they'll name a commonwealth somewhere that has 5 or 6 different jurisdictions plugged into it, and various other things that make it unclear whether they actually intend to arbitrate or mediate or litigate. And so that's often, at least in the old days, was a function of the people doing the transaction not having a collaboration with the folks who do the dispute resolution, getting together and what was referred to as a seamless team that works as sort of together to get these things done in a proper way. I want to pitch to Grant here just to sort of, without giving away any Morrison and Forrester secrets, is your sense of it the same in terms of how one focuses on the front end and the difficulties with pathological clauses and the policy in-house about who gets involved at 3 a.m.?
Short answer is yes. Would you like me to elaborate? Or?
No, short answers are good. It just proves that all international firms feel each other's pain and ultimately do something.
Yeah.
Something
I do
about
get
it.
consulted sometimes by my corporate colleagues on arbitration clauses when they're drafting. And I sometimes even give presentations on that subject.
I have a colleague that worked at a major firm, and he said there was a time when they could proudly claim that they were the only major law firm that wouldn't let a contract go out of the building unless the disputes people had looked at it. Now today it's fairly standard. I wanted to allow some time for questions. I have more questions to pitch, but any questions from our colleagues in the audience?
One question.
Yes?
I should know the answer to it, but I don't. The United Nations contract, UNCITRAL services contract, doesn't that involve arbitration clearly? UNCITRAL arbitration clauses, are they not included in the context of the...
I mean, arbitration clause, UNCITRAL.
UNCITRAL rules, arbitration rules,
Yeah.
I think.
I'm sorry.
Yeah.
If we have one of those clauses in a contract,
Yeah.
does that not bring in,
So,
cover the issue that we're...
I mean, if I can sort of reframe a little bit your question, as I understand your question, which is the question I'll ask, whether it's the one you intended or not, aren't these clauses, if you use a standard clause, fairly foolproof? In other words, the UNCITRAL rules say, you mention arbitration in the UNCITRAL rules, in many jurisdictions that's enough to send it to arbitration, keep it out of the courts. Yeah, and so part of what the question is how elaborate to get in drafting these clauses. I mean, do we really need to add the seat? Do we need to mention the IBA rules of evidence? Do we need to maybe, drawing on yesterday, mention the IBA guidelines on party representation? Any of those kinds of things. In other words, as a policy matter, do you stick to the basic elements in the institutional clause, be it ICC or other, or is there a trend toward what I see in some American contracts, very elaborate dispute clauses? Thank you for that question, by the way. Great question.
My recommendation is normally we just follow the simple arbitration clause, which was recommended by institution, unless you have really confident about what should be included in a contract. I noticed that American practice that we have more detailed arbitration clause, but sometimes, and I would say more often, that caused problems interpreting arbitration clause. When you have dispute on dispute resolution clause, then it's somebody really try to avoid performing the obligation. There's paradise. So we will go just 5 years resolving dispute resolution clause. Even we have no chance to dispute on the merit. So normally I recommend just the institution clause, recommended clause. If you really want to add, in case of ICC, maybe you want to add something that how you appoint the chairperson. Maybe that's all. Then if you added anything more, then you might have some sort of problems in dispute resolution. I don't know what the experience is.
Yeah, I would add just a couple of points. There's a division. If you prefer an ad hoc arbitration, such as UNCITRAL rule, that's okay. However, then you need to have a certain level of specificity. If you just have an UNCITRAL arbitration, then there are a couple of points that you have to determine, and arbitrator need to kind of understand where would be the seat and what language you would do, and so forth. So then appointing authorities. So then there's a possibility that if you don't have any supervisory authority, then arbitration will be dragged on, because if somebody, especially normally the respondent, the best, their policy is to dragging on and defer and delay the procedures. So, but if you choose one of the well-known institutions like ICC, Singapore Institute, or LCIA, then they have some more of a set menus, if you will. But if you go a little bit further, then probably there are a number of developments in these institutions. For example, ICC recently amended arbitration rules in 2012, which allow emergency arbitrator. So then, but there is some limitation. The contract was drafted before then it's not applicable. So if you have an idea that the emergency arbitrator or emergency, interim measures are important for your case, then you may just opt in to agree to the new rules. It's the same as Singapore rules and others. So there are a couple of points that you may have a bit more detailed, choices for your case.
With my last question, I would like to sort of give an advertisement for the next panel by asking you to briefly comment on Korea's recent involvement in investor-state arbitration. I know that some of you are involved intimately in the current disputes, and I know there's only so much you can say, but just talking about the phenomena in general and maybe how it is different from standard contract-based arbitration.
Yeah, investment treaty arbitration, I always say that we have more conferences than actual cases in the world. So that happens in Korea, and we have so many conferences and the event talking about investment treaty arbitration, but nothing happens until recently. But in Korea, something happens, then it starts. That happens. Same thing happens in investment treaty arbitration. We have the first investment treaty arbitration recently. I'm personally involved in. I'm not supposed to talk about too much about the case because my opposing counsel is sitting here. But Korea had about 90 BITs, and 8 FTAs, and we maintain very clean records of ours. So everybody's, whenever we have the international conference, people ask us, what happens in Korea? You have so many BITs, how come you have no dispute? So our government said, oh, we maintain good record because we are always good. So then the American investor break the ice, and they filed exit arbitration through the SPAs and other jurisdictions. Then we have a great debate on the about this investment treaty arbitration system when he had a negotiation with the U.S. and the Korea-U.S. FTA. So we have a lot of demonstration. 167 judges signed a petition to Chief Justice to reconsider the position of adopting this ISDS system in Korea-U.S. FTA. Although at that time, Korea already have almost 90 BITs, which include this investment treaty arbitration system. Then everybody talk about the ISDS, and even the taxi drivers talking about the ISDS in Korea. Then what happened was not using Korea-US FTA, but using the pre-existing BITs. We had the first exit arbitration. And then after that, Korean investors, Korean companies interested in this ISDS system. And I was lucky enough to initiate the first investment treaty arbitration against the foreign government. Again, this is confidential. I'm not supposed to specify which company and against what specific country. But that was first. This is a ad hoc, pure ad hoc, even not the UNCITRAL, just a pure ad hoc arbitration. And then we have recently have one exit arbitration against Chinese government, again from Korean investor. And there is some other cases is supposed to happen in the near future. So that shows that the Korean investors may be going to use more frequently use this investment treaty arbitration.
So as a phenomenon then, just to capstone it, you have claims by Korean investors against foreign countries, and we have now at least one claim against Korea. And so we're sort of seeing both sides of the treaty, so to speak.
Yes, and you know, another example is that we are retained by a Korean companies who already got the arbitral word in Vietnam, because they want to enforce it in a Vietnamese code and a Korean code. And there was some issue in the Vietnamese code. So we are retained, and we actually gave notice to the Vietnamese government that we have instruction to proceed investment treaty arbitration against Vietnamese government because the court is hesitate to enforce it. And what happened was the Vietnamese government instructed that company, government-owned company, to pay the whole amount, including interest and attorney fees. So that is quite useful things, you know, in the investment treaty arbitration. And the client are obviously very happy with the result. So that was happening. I understand that some other law firms also involved in similar occasion because I have a similar experience in Mongolia. So we represent the client. In that case, even without any formal notice, we just send a simple letter to say that our firm is instructed to reconsider this possibility. Then we got result. So I was blaming the lawyers who read this letter. You know, we lost the case, but that is quite effective method. You know, or the equipment to enforce your right in some jurisdiction.
That's I will encourage the other two colleagues to save their questions for the next panel, which they can offer from the audience. It remains now for us to just thank in the time-honored way our panelists